Hi, it's Mike DelSignore, Massachusetts OUI Lawyer. Today's video, I want to talk about what happens if you're arrested for OUI and your case is going to be heard in the Lowell District Court. So what happens, OUI cases all start out the same way. Your first court date is going to be the arraignment. You're going to enter a not guilty plea, get a further date to come back for pre-trial. But keep these things in mind. First of all, when you're charged with a first offense OUI, you're not looking at jail time, you're charged with a misdemeanor. If you admit to the OUI, you're going to get a continuance without a finding, 1 year probation, have a 45-day license loss. If you're found guilty after trial, generally you're going to get pretty much the same resolution of the case. First offense OUIs, they're very winnable cases. If you did not take a breathalyzer, it's a subjective case. In other words, the officer is arresting you based on an opinion. That opinion is you had too much to drink. The officer has no basis other than the opinion. They're going to say they smelled alcohol, your speech, things like that. But you could have certainly had socially drank, had 2 drinks, and it could be a smell. Often the slurred speech is not present. Typically that's something that's exaggerated, overstated. If there's video evidence, it usually shows that there really wasn't slurred speech. His speech was normal. I haven't really seen, and they've been using video for a long time now, probably for the last couple of years. State police have had video. I've seen very few cases with real slurred speech. And I think if you do a trial with a judge, I think the judges know that observation, while stated in almost all reports, is largely absent from the objective evidence. So one way to establish reasonable doubt is whenever we can find something objective that we can show a judge or jury and it's not true based on the testimony of the report, it's a long way towards establishing reasonable doubt. So what are some of the things police look for when making an arrest for OUI? Well, first, when they do field sobriety tests, the assumption is if you don't do perfectly on these tests that you're impaired by alcohol, but that assumption can be flawed. There's a lot of reasons why somebody may not balance for 30 seconds on one leg. First of all, the instructions are confusing. You're told to keep your foot up until the officer tells you to put it down. So most people ask, well, how long? So you're wondering how long. You don't really know the rules of the game. You're told you to put your foot up. You don't know what success is. It's very difficult to do anything without knowing the ultimate goal, how long. So the officers hide the scoring from you. It's not fair, essentially. You might have a knee, leg, or back problem that could make it more difficult for you to balance on one leg. You might have high heels on. If you have to take them off, it's really not a fair assessment. The 9-step walk and turn is similar. They're looking for 8 different things. The 2 of the clues are in the instruction stance. They want you to stand in that heel-to-toe stance and not start until they tell you to go. Then there's 6 other clues, including the correct number of steps, maintaining heel-to-toe, staying on a straight line, not stopping while walking, proper turn, and counting your steps. So in a lot of reports, you won't really see many details of what you did wrong. You'll say, hey, missed heel-to-toe, unsteady, failed. Well, that's a great report. So when I look at the police report, there's a lot of things that I'll see that I'll be able to tell you about in terms of how the case is likely to go at trial that you may not realize just reading your report for the first time. So the good stuff basically is not in the report. So you have to understand the police officer's training in order to understand how the testimony is likely to come out at trial. Now, if you took a breath test and it's over the legal limit, don't assume you can't win the case. Breath test evidence can be unreliable, and it doesn't always come into evidence. We can file a motion to exclude the breath test results from evidence so the judge or jury doesn't consider those test results. So a breathalyzer is making some assumptions about you, about your body type, about how your body processes alcohol. It's called the blood-breath conversion ratio. That ratio is not the same for everybody. So this machine may overstate your BAC. So breath test cases are winnable. I've won them routinely over my career, and I can help you, tell you what I think the best outcome for your case is. So if you're charged with OUI, keep in mind you have a subjective case. Many people have been in the same position you've been in. It doesn't mean you can't win the case. It's a crime of opinion. We could call potentially most of the time, I don't call any witnesses, but we can. We can call people you're with. If you were at a party, celebration, you could potentially testify and explain how much you have to drink. But you have no burden of proof. Most of my clients never testify. I win the case, establish reasonable doubt by showing the officer's opinion was too subjective to get to the high standard of proof we need in Massachusetts for a conviction, proof beyond a reasonable doubt. You have questions, call, text me. My name is Mike DelSignore, 781-686-5924.